right, folks, we'll get you back to court in just a minute, but first, here's a quick look at some of the other cases that we're tracking here at Court TV. In California, it is now day 3 of jury deliberations for a mother accused of leaving her 2 young sons in a hot car while she got lip filler. And in New York, Luigi Mangione is back in court today for what's expected to be the final day of a weeks-long suppression hearing. No cameras in that courtroom, but we'll have updates throughout the day. And we are in Kentucky. We're standing by where former Sheriff Sean Mickey Steins is back in court next hour for a hearing to discuss several motions, including the state's motion for a change of venue. Of course, we'll keep you updated on all those trials throughout the day. But for now, we're going to head back to Nevada, where we've been watching a hearing in the crash intended to kill case for Jose Gutierrez. The 19-year-old is accused of speeding into a line of stopped cars, ultimately killing 3, including his pregnant girlfriend. Now, the defense claims that Gutierrez suffered a seizure right before the crash, but prosecutors believe the car data tells a different story and that he might have been targeting his girlfriend. Let's head back into court now, where a trauma surgeon who treated the defendant has just taken the stand.
Now, I want to direct your attention to November 18th of this year. Were you working in your capacity as a trauma surgeon at UMC on that date?
Yes, sir.
And specifically, I want to direct your attention to the afternoon. That afternoon, do you recall getting a number of patients into the emergency room?
Yes, I did. I sit next to the ER doc and the unit clerk, and right behind us is the tele, so I get advance notice on anything that may or may not get activated. And we had a call from EMS that they had multi-car collisions with multiple casualties, and they were bringing us the first of 3.
Okay. So, I guess that first group, you had 3 patients come into the emergency room, right? Do you recall one of those patients by the name of Jose Gutierrez?
Yes.
Okay. Would you identify, or would you be able to identify him if you saw him?
Yes, he's sitting right over here.
Okay. Your record reflect the witness identified him?
I don't recall.
Okay. So you saw Mr. Gutierrez on the afternoon of the 18th, right?
Correct.
And when he was coming into the emergency room, can you describe his state of well-being, what kind of injuries he had when he was coming in?
Yes, he was, of the 3 we had, he was probably the least injured. He came to us, he had obvious deformity in his right arm with like an open fracture. He was awake and alert, following commands, and complaining of also sort of low to mid back pain posteriorly, and then had generalized abdominal pain and some issues, we thought, with his breathing, especially on the left side.
Okay. So based on all of that, did you come up with a kind of a treatment plan for Mr. Gutierrez?
We do. We follow a fairly strict algorithm so we don't miss anything, but you know, I always have one of my residents will start and do head to toe, and the first thing they'll do is they'll assess someone's what we call their Glasgow Coma Scale, or GCS, and it's a metric that looks at whether people are opening their eyes spontaneously, whether they open a voice, whether they don't open them at all, whether they're like answering questions or just moaning incomprehensibly, and if they're moving extremities following commands. And so his GCS was 15, meaning like my GCS is 15 right now.
Okay. Can you kind of describe what that score actually signifies, GCS 15?
It tells us the level of consciousness that a patient has and or their neurologic function. So it does both things. So like if someone comes in and their eyes are open, that means that they're looking around, they're obviously awake. If you have to shout at them or talk to them and get them to open their eyes, or you have to give them sternal rub and they might open an eye, it's giving you a sense of like, do they have a traumatic brain injury? And then following motor commands is like, can they give you a thumbs up? Or do they only do things like, things are getting worse when you're starting to posture or extend, meaning you're having injuries with the brain stem. So it's a standardized thing now in the medical literature. We always try to see if we can come up with something better, but it works really well quickly to assess the status of a patient. As a trauma surgeon, what I'm always looking for is this person able to protect their airway? And if they're not, then I need to intubate them so I can protect their airway for them.
Gotcha, okay. And so you mentioned his score was GCS 15, and your score would be GCS.
That's a normal, that's a normal. Now, not to say that he wasn't injured, but his brain was intact and he was able to follow commands and answer questions.
Okay, so based on the injuries that he did have, did you come up with a specific treatment plan for those injuries, specifically to his back, his arm, and that kind of thing?
Yeah, actually, his biggest injuries at the time when we first evaluated him was he had chest trauma, posterior chest trauma. He had absent breath sounds on the left, so we wound up putting in a tube to evacuate the air in his chest. And then when we were able to, at that point, we felt he was stable. I had some x-rays that showed some rib fractures and looked like pulmonary contusions. We took him to our CT scanner and obtained what we call cross-sectional imaging, where we can look inside the body with x-rays and create almost like a three-dimensional view. And at that point, we found that he had posterior rib fractures. He had an injury to his liver, injury to one of his kidneys, an injury to his spleen that weren't life-threatening, they weren't actively bleeding, and then some pulmonary contusions, and then ultimately we saw that he had this, we have more imaging of the right arm that showed he had open radius and ulnar fractures.
Okay. So based on all of those injuries and the tests that you ran, I'm assuming he was admitted to the hospital, right?
Yes, he was.
And were you labeled as the admitting physician for Mr. Gutierrez?
Yes.
Okay. Were you also labeled as the attending physician for Mr. Gutierrez?
Yes, I was.
All right, let's bring in our guest for this hour. Joining us to discuss from the great state of Minnesota, criminal defense attorney and former prosecutor Jack Rice. Jack, great to see you as always. Wanted to check in about this preliminary hearing. Oftentimes in these preliminary hearings, prosecutors want to keep stuff a little closer to the vest, right? Just enough to get them over that line of probable cause to get this case to move forward. Here we're hearing from a trauma surgeon who treated the defendant. Any ideas of why we're hearing from this particular witness? I imagine it might have something to do with the claim by the defense that this was a seizure situation rather than some sort of intentional act.
I think so too, and you're right, Michael, that the strategy here for the prosecution is to give the court enough and no more than enough, because obviously you show everything that you've got. It gives the defense the opportunity to pivot. And I can tell you, I'm shockingly jealous of this. In my jurisdiction, generally speaking, we don't get this. And so as a result, we walk into trials frequently almost blind. We get discovery, but these are pieces of paper that have words on them. You don't get live testimony that gives you the ability to assess what somebody looks like, how something works. It's a much different scenario, and it can potentially change the strategy of a case.
Yeah, I agree with you 100%. It's a real boon for defense attorneys, and I would advocate that this should happen in every state, to be honest with you, to sort of even out the system, because oftentimes it is weighted in favor of prosecutors. In this particular case, Jack, there's an intentionality part that the prosecutors have to prove because they have charged first-degree murder. At its essence, it feels like a domestic violence case, according to what the prosecutors are claiming. What are your thoughts on this idea of proving the intentionality in this particular case?
Yeah, that may actually be the most challenging aspect of the case. I mean, one of the criticisms I have, not in this case, but in general, is that sometimes I will see prosecutors overreach, and they will charge at a higher level than I think they may actually be able to prove. Now, sometimes that's done because they think they have the evidence, but sometimes it's actually done as a process to drive the defense to resolve a case. And sometimes what you have here is the extraordinary trauma that comes with the idea of actually trying that case, because sometimes you have a first-degree charge, you may be looking at life in prison, and almost certainly so, versus that second degree, or whether that's a manslaughter case or criminal vehicular homicide case. Those are always different, and they don't come with that intentionality.
Yeah, fair enough. And just as a point, this is a first-degree murder case, and it is going before a death review committee to figure out if they want to charge or have death as a possible penalty in this case. It hasn't been decided, so we'll have to wait and see how that plays out. But interesting points. All right, Jack, stand by. Folks, stick around. Coming up, more from the trauma surgeon in the hearing for Jose Gutierrez. Plus, Brian Walsh was sentenced to life in prison without the possibility of parole today. Court TV's Matt Johnson joins us live from Massachusetts, and that's next. Keep it here on Court TV. Welcome back. You're watching Court TV. I'm Michael Ayala in today for Ted Rowlands. Turning now to Dedham, Massachusetts, where Brian Walsh has been sentenced to life in prison without the possibility of parole for killing his missing wife. Now, Anna was last seen alive on New Year's Eve back in 2023. And prosecutors argued at trial that Brian killed her believing that she was having an affair, then dismembered and disposed of her body, which has never been found. Let's go now to Dedham, where we find Court TV crime and justice correspondent Matt Johnson. And Matt, the judge called Walsh barbaric today in court. Tell us about that.
Yeah, that was a big moment in court today. The judge not holding back as she called him barbaric for what he did to his wife, killing her, then dismembering her, dispersing of her remains. That statement made before she handed down that life sentence without the possibility of parole. Let's watch.
As to the nature and circumstances of count 3, the improper disposal of Anna Walsh's body, the seriousness of your acts cannot be overstated. Your acts in dismembering your wife's body and disposing of her remains in multiple area dumpsters can only be described as barbaric and incomprehensible. You had no regard for the lifelong mental harm that your criminal acts inflicted on your then 2-, 4-, and 6-year-old sons, not only in taking their mother, but also, as is specific to this charge, in never being able to properly grieve that loss, to say goodbye to their mom.
Very tense moment in court today. Look at this. New video into our newsroom. Brian Walsh, convicted killer, going to serve life behind bars without the possibility of parole. Shackles and handcuffs being let out. Extra deputies with him this time, not saying a word, just like he didn't give a statement in elocution or make any remarks in court before the sentencing today, addressing the court. Why did he kill his wife? What did he do with her remains? She can never have that proper burial that her family wants so dearly, Michael.
And Matt, we also saw Anna Walsh's sister on the stand. What stood out to you from her statement to the court?
Alexandra made the trip from Canada. That's the reason why this sentencing was postponed by an entire day, so that she could be here. And wow, it was just so powerful. You could hear a pin drop in the courtroom. She had a written statement. She walked up to the witness box, and then at one point in time, the judge, she got up from her seat at the bench and she walked over to the edge and leaned over so that she could see the tears welling up in this witness's eyes, Anna Walsh's sister, as the sister looked at that killer across the room and made this statement.
Anna was a mother, a daughter, a sister, and a friend. Her life was unfairly taken. We asked the court to consider the permanent, long-lasting impact this loss has had on our family. Thank you for allowing me the opportunity to share the full weight of this incomprehensible act. Anna will never be forgotten. We will carry her light and her memory with us forever.
Never forgotten, always in their hearts. All right, take a look at this. So as she exited the courthouse, the reporters were trying to ask her questions about facing her sister's killer. She wasn't answering those questions. We know that she made the statement to prosecutors that she believes that justice has been served. Outside the courthouse on the steps, she did answer one question. She said that she was here to honor her sister and be the voice for her sister, Anna. Michael?
Yeah, and kudos to the court for waiting that day so she could have that opportunity. And Matt, I understand you were able to catch up with Brian Walsh's mother. She was in court pretty much the entire trial. After today's hearing, did she have to say anything?
Yeah, par for the course, not answering my questions yet again. I ask her each and every day if she would like to make a statement. She's been in court for the 8 days of the trial, listening to those 48 witnesses that took the stand. She's been supporting her son, wearing a brooch that he gave her each and every day. One day she was trying to pass him a note. That was the beginning of the trial. And today the judge remarked about the letter that she submitted, a character letter in behalf of her son. And the judge said, I don't agree with this letter at all. She didn't read it out loud. But I asked Diana Walsh about that as she left court today. Take a listen. Mrs. Walsh, did you hire a private investigator to look after Anna after you visited a spiritual advisor? Do you still believe that your son is innocent? What was in the letter that you wrote, Mrs. Walsh? What was in that letter?
Anything you want to say about your grandsons?
Did you know that her body was in the home when you came to visit? What will happen with the children? Inside the courtroom, this convicted killer who killed his wife, dismembered her, and then tossed her remains like trash, according to prosecutors. When he left today, he didn't look in the direction of his mom, and he usually does each and every day. He usually glances over at her and says something to her. Today, he didn't look in her direction, and they had no moment, is what she tries to create each and every day. Now he's going to just see 4 walls for the rest of his life as he heads to prison, Michael.
Yeah, and Matt, he's already had some issues in jail a little earlier. We'll see how prison works out for him. All right, Matt, thank you so much for that report. Appreciate it. Live from Dedham, Massachusetts. Let's bring in our guest still with us, criminal defense attorney and former prosecutor Jack Rice. And Jack, you know, Mom was always this sort of shadowy figure in this case in my mind. But, you know, the machine that is the criminal justice system sometimes can be a little harsh. But I got to say, as I mentioned, and I want to get your thoughts, kudos to the system for waiting that extra day to give the sister the opportunity to deliver that victim impact statement live and in court.
Yeah, no question, Michael. When we think about this system as a whole, I mean, we deal with tragedy every day, and we deal with it in countless numbers. It's not just once, it's hundreds of times over decades and decades and decades. And sometimes we can be flattened by what that means. The brutality of what that means in an individual or in a family's life, that's a reality. And sometimes that is what brings us back into the reality of what it means too. And you realize just how critically important a sentencing is. And in many ways, the most important part of the sentencing really are the voices that get to be heard, finally. They get to talk about the person that was stolen, the person that was taken, the brutality that was placed upon that person, and really to air out what this means for them, for their families, and most importantly, the memory of that person that they never get to hold ever again.
Now, based on that first-degree murder conviction by this jury, Jack, the court had no option. It was life without parole. But the rhetoric of the judge, I think, was pretty strong. You don't often hear judges call defendants barbaric. Love to get your thoughts on that.
Oh, no question about that. And remember, this is one of those aspects where you realize the humanity in the judge and the brutality of what this meant. And what you will sometimes see is the judge who was always trying to remain professional. But I also think there was something about this case that hit this judge personally. And if you listen to the sentencing as you just aired it, the notion of what he did by cutting her to pieces and then placing her in various parts of the city so she could never be found, what that does to a child, the ability to never be able to get true closure. For some reason, that piece, even over the murder itself, was something that this judge grabbed upon in a way that I thought was really startling. And at the same time, it makes us all remember we are all humans trying to work in a very imperfect world and in a very brutal system that deals with this kind of brutality every day.
Yeah, no question, Jack. And again, Brian Walsh sentenced to life in prison. As the judge said, your natural life. You will be in prison for your natural life. All right, Jack, stand by. We'll take a break here, folks. Coming up, we're going to head back to Nevada for more of the hearing in the crash intended to kill case for Jose Gutierrez. We'll be right back. Keep it here on your front row seat to justice.
Coming soon to Court TV.
A Microsoft executive gunned down.
Now his ex and her new husband are charged with his murder.
I'm gonna kill her.
An alleged murder plot involving a family's au pair and the married father she worked for.
A social media sensation, now a suspected killer.
Why do you have something against me?
She wrote a children's book about her husband's death. Now she's accused of killing him.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
We have some breaking news out of Florida where a judge has denied Courtney Clenny bond ahead of her newly scheduled trial date. The former OnlyFans model appeared in court today where the attorneys discussed several motions, including a motion to dismiss, which the judge also denied. The judge then set a trial date for April 16, 2026, and that trial is expected to last about 2 weeks. Clenny is claiming self-defense in the fatal stabbing of her boyfriend, Christian Abumseli, and we, of course, will keep you updated with any new developments coming out of there. All right, we're going to head back now to Nevada, where we've been watching a hearing for a teen accused in a deadly car crash. 19-year-old Jose Gutierrez is accused of speeding into a line of parked cars earlier this year, killing 3 and injuring others. Now, prosecutors say the motive was to kill Gutierrez's pregnant girlfriend, who was sitting in the passenger seat of his car at the time. Let's head back into court now, where we've been listening to testimony from the trauma surgeon who treated Gutierrez after that fatal crash.
Can you describe the difference between admitting and attending and what those mean?
I can. Usually, and for the trauma service, it's rare that the attending physician and the admitting physician are different. The exceptions would be, I may be the attending physician, but like as a kid going to the pediatric ICU, would then be admitted to the pediatric intensivist. For all intents and purposes, like for Mr. Gutierrez's state, we sent him to the ICU because of his lung injuries and rib fractures, and that he had these 3 solid organ injuries. So I was the attending a record and the admitting attending, but he actually fell under the service of the ICU attending. So you'll see on there, I think, that Dr. Jamie Humberger is also one of the attendings.
Okay, but you were the attending when he just comes into the emergency room.
Yeah.
He's admitted. Okay. Now I want to talk about seizures. During your experience as a doctor and in your medical training, have you come across people who have had seizures?
Yes.
Okay. But fair to say more than one?
Yes.
Okay. Now, when someone has a seizure, immediately after they have a seizure, do they go into something called a post-ictal state?
Depending on the type of seizure, yes. And the type I usually see, yes, they're post-ictal.
Let me ask you this. Have you ever witnessed someone have a seizure and not go into a post-ictal state?
Not in my experience.
Okay. Can you describe what a post-ictal state is?
So a post-ictal state is, to go back, there's the pre-ictal in seizures where some people will have an aura, they'll have a smell, some people have different things. There's a broad spectrum of how people behave. Then there's the ictal state where they're actually experiencing the seizure. And that's in most of the seizures I see, because I treat adults and in trauma, people will have what you classically see in the movies where they have sort of that myoclonic or tonic-clonic where they get rigid, they're spasming, and they're not aware of what's going on. And then afterwards they appear confused as if like they've woken up from a nap or they hit their head and they're concussed, and they look around but they're not answering questions and they're not interactive.
Okay. And how long does the post-ictal state typically last?
In my experience, it's anywhere from 5 to 15 minutes.
Okay. So obviously 5 to 15 minutes, not a long time, but still it always happens after the seizure, right?
Yes.
For at least 5 minutes. You mentioned that when people are in this state, they're not answering questions.
Correct.
Are they able to communicate verbally with other people?
No, they were like looking at the Glasgow coma scale. It's either incomprehensible words or groaning kind of sounds, if they're making any sounds at all.
Okay. What about like reciting things from memory? Would a person in a post-ictal state be able to recite something from memory?
Not that I would be aware of. I can't.
Okay. And like you said, would you describe this person as not coherent?
Correct.
Okay. Pass the witness, Your Honor.
Cross.
So you said it depends on the type of seizure.
Absolutely correct.
And you said you've seen seizures multiple times in your career, but Seizure is an area of medicine. Epilepsy is an area of medicine, an area that you specialize in?
Absolutely not.
Okay.
That would be a neurologist.
And how much experience would you say you have with epilepsy treatment?
I treat acute epilepsies in the pre-hospital or in the hospital setting when people are actually in what's called status epilepticus, where they're having these myotonic-clonic seizures, because the goal is you want to break those as quickly as possible.
And what's a tonic-clonic seizure?
Where people are, there's a whole list, but it's where your muscles are going through like this rhythmic spasming, and the person's not in control of their nervous system.
Okay. What other types of seizures are there?
There's everything from, our little kids get febrile seizures to things that are related to inborn errors like genetic mutations to mostly in the adult population. The people we see them in are people who are withdrawing from alcohol, and you get them in people who are on certain medications or certain drugs that can have them, or it's the result of previous trauma to the brain or strokes. And then there's you'd have to talk to neurologists. There's a giant laundry list of things. My friends who are neurologists, they say it's really, seizures are sort of a physical manifestation of something that's going on structurally or biochemically within the brain, but it's a broad spectrum of things that can cause seizure disorder.
So there's all different types?
There's all different types, yeah.
And when you're referring to this pre-ictal, ictal, and post-ictal state, that doesn't apply to all types?
You'd have to ask a neurologist. It's used a lot to describe seizures, but I don't know if people who are having febrile seizures, if those kids have a pre-ictal state or not. I couldn't answer that for you.
Gotcha.
Yeah.
And we might be out of your area of expertise, so just say if
sure.
you are. But if a person has seizures, how would medical diagnose somebody with epilepsy?
Well, my experience from having patients who we thought had seizures is we get neurology involved. They will usually do a long-standing EEG where they put electrodes on the scalp and pick up on the electrical activity of all the hemispheres of the brain. And they can tell from those sometimes if there's underlying seizure disorders. They also will obtain cross-sectional imaging. CT scans are the first step, but really they'll go to an MRI of the brain to look for structural defects.
Okay. And you said an ECG measures electrical?
EEG.
EEG.
Electroencephalogram.
And is that something that's normally done as part of the process when somebody comes to the ER for a trauma surgery?
No, that would be done once they get into the ICU if there was concern for ongoing seizure activity, especially in a intubated and sedated patient, because one of the risks we have in critical care is that you can have a patient that is in a seizure that's unrecognized and not treated, and they can literally, if you don't interrupt and I'm probably paraphrasing this, or a neurologist wouldn't like this, but basically the electrical storm that's going on in the brain can cause permanent damage. So the idea is you need to break that, and the goal is you try to break those seizures within 60 minutes or sooner if you can, and you keep escalating the medication that you would use to try to break the seizure. But sometimes the only way to tell that is with an EEG.
And does the EEG have to be done within a certain amount of time to be effective?
You mean to diagnose it?
Yes.
Yes, yeah. I think you need to know what's happening.
Well, let's say somebody has a seizure.
Yes.
How soon after does an EEG need to be done?
I think I see what you're saying. So if it's like a witness seizure, like a patient that I'm treating and I watch them and they go into an obvious seizure, not one of the non-obvious seizures, we would break them from the seizure with medications. Once that was done, we would admit them and then we would ask neurology to see them, and then they would do an EEG sometime within the first 24 hours.
Okay. And what if somebody has a seizure disorder and they suffered a seizure days prior? Would an EEG still be able to confirm that they're suffering from epilepsy, or is there kind of a...
I don't know the
wouldn't be conclusive at that point?
I don't know the answer to that.
Okay, thank you for being on.
Yeah, absolutely.
And again, if this is out of your depth, just say so. The post-ictal state on direct examination, you said, lasts between 5 and 15 minutes.
That's been my experience with the type of seizures that I see.
Is that your own anecdotal experience? Like with patients you've seen, it's like, hey, between 5 and 15 minutes.
Yes.
Are you familiar with any literature on what those time spans are?
They can be somewhere, well, some people won't have an obvious one. And then I've heard stories, or not heard stories, read that they can last for more than an hour, depending on how bad it was. And sometimes that has to do, my understanding is like, how long were they in what's called status epilepticus? Like you have a patient who was in status epilepticus for a really, really long time, and they finally broke them. They can remain in this sort of post-ictal, not comatose, but semi-comatose state for quite a while.
So sometimes they can go on for quite a while. You also said that sometimes they're not obvious.
Yes.
And what did you mean by that?
I mean, there's, like my experience with my kid having a febrile seizure, they went back to normal after the seizure.
All right, that pretty much sums up the pertinent parts of that hearing for Jose Gutierrez. Now, the judge ultimately ruled that there was enough evidence to bind him over for trial. Gutierrez has pleaded not guilty, and his case is now going before a death penalty review committee. All right, stick around, because coming up in the next hour, we're going to switch gears and head to Kentucky, where former Sheriff Mickey Steins is back in court. Keep it here on Court TV.
Well, welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala, and we're both here today giving you your front row seat to justice. And we begin in Kentucky this afternoon, where we're standing by for a motions hearing to begin this hour for Sean Mickey Stein.
Some of the issues expected to be addressed are motions for change of venue, for bond, and for dismissal. The former sheriff is accused of fatally shooting Judge Kevin Mullins in his chambers in September of last year. Just hours before the shooting, Steins was in the judge's chamber, appearing to have a very casual conversation with him. There's video of it, and that was before he and the judge went to lunch.
Now, shortly after returning from lunch, video shows Steins enter the judge's chambers, and he takes out a gun, and then he begins shooting him from point-blank range. Now, we froze the moments when that gun was fired, but I want you to take a look at this. Now, after the shooting, you see people running out of the courthouse, and then you see Steins casually walking out, go down the stairs, and walk away.
What a bizarre case. Eventually, we know he surrendered to the police. He was indicted days later for the murder. We want to take a look at some of his initial conversation with officers after he was arrested in this police body cam video.
When all this first started happening, Justin Hunsaker said, "What'd you do? What'd you do?" and started asking me questions. So I want that to be on the note.
Okay. That's your recorders right here. Well, anything he said?
I don't know about y'all's recorders now. Come on now. I just want a fair...
You wanted the recorders on while ago, Mickey.
Yeah.
So, hey, Mickey.
These are killing me. I just want a fair trial, guys. Get me to where... Let them try me here, wherever.
Tell us what happened today.
You tell me.
We don't know. I just got here. I just know that Judge Mullins was shot. So tell us what happened. What led to that?
Do you want to talk at all, Mickey?
Earlier you said you wanted to talk about it. Listen, Mickey, if you don't want to talk, that's fine. I ain't going to force you to, okay? We're not going to force you. If you don't want to talk, that's your right. You don't have to.
Yeah.
I read you your rights. Well, and you know, you're the sheriff. I mean, you know just as much as we do.
Okay.
But it's up to you.
If I can see my daughter in person here.
Before you leave. Is that what you want?
At the jail.
At the jail?
Yep. At the jail, through the screen, on the phone, I want to see my daughter in person. And then after that, I'll tell you everything at that jail, in front of cameras, video recorded.
Where's your daughter at?
Huh?
Where's your daughter? How do we track her down? Where's she at?
She was at LCC earlier. She was at LCC. I talked to her.
So, now, Mickey, I want to kind of, for your daughter, let's talk about this, for your daughter, okay? If she finds out that her dad is being arrested for shooting the judge, and she's in high school. I didn't know how old she was, so I didn't know. So she's in high school. What is she, a senior? That's going to be hard.
She will want to see me. She will want. Now, come on, guys, be fair to me now. That's all I'm asking.
I'm being fair. That's the only thing I just wanted you to think about that. How is she 18?
Be fair to me now, guys.
Well, hold on. Is she 18?
Be fair to me now.
No, I'm asking you.
Come on, I want to see my daughter in person.
Is she 18?
I want to see my daughter in person.
How old is she, Mickey? I do have a kid. I've got grandkids.
Yeah. I got 5 grandkids. 5 grandkids.
Listen to you.
I just want to see my daughter, man.
If she's not 18, we're going to ask your wife. We have to ask your wife if it's okay. You know that. Is she 18?
Christine and LaShawna both said they were both on their way here. When they were in here, there was all kinds of people in here just running around chaotic. So how am I going to tell you what happened?
To the judge?
Yeah. You know, Christine LaShawna said my wife and daughter's on their way.
You just said, how are you going to tell us what happened? Everybody's running around chaotic.
It was. I just want to see my daughter.
Is she 18? How old is she? If your wife's out there with her, if she ain't 18, we can ask if that's okay. But if she's 18, we just ask your daughter. So that's what I'm getting at. If she's not 18, we have to ask your wife. Do you think they're outside?
Shawn and Christine said they was on their way. Let me talk to them too.
You want to go ask them about it?
Hit that button right there.
No, this is recording.
His guys, come on now. Be fair to me now.
Mickey, we're not being unfair to you.
You want to drink water?
Yeah, now be fair to me, guys. Y'all gonna kill.
It's interesting. He, the sheriff, tries to put a condition on it, saying, if you will let me see my daughter in person unrestrained, then I'll tell you everything.
It's interesting.
It is. Now, just days before the shooting, Steins was deposed, for a lawsuit involving sexual assault allegations against a former bailiff who is accused of having sex with the inmates inside the courthouse. We're going to have more of that coming up a little bit later.
All right, let's bring back in our guest, still with us from St. Paul, Minnesota, criminal defense attorney, former prosecutor Jack Rice. And Jack, the thing that jumped out to me was, as Judge mentioned, all the negotiating that was going on. And it's an interesting dynamic because he's the sheriff in many ways. And those folks who are talking to him, they know him, probably respect him, may even be someone that is over them. So talk to me a little bit about what we saw there in that interview.
Oh, this is so complicated too. And if you think of it this way, there are a lot of circumstances where you have people who are in law enforcement, people sometimes who have been judges, people who have been lawyers, they all get involved. They're all involved in this process. And you're seeing this interrogation, and you're also watching these officers sort of they're pivoting around this question because they're trying to get something out of Mickey. And so that issue is a very big question. And remember, everybody is driven differently. Everybody will talk or not talk based upon a whole series of things. And one of the tools that a good interrogator uses, and this is something I learned who are trained, taught, told to they will do it anyway. I have to be honest. I can't count the number of times I spoke.
Charged in count 3, signed 4. Fourth count. We, the jury, impaneled to try the above entitled case, find the defendant, Maya Hernandez, guilty of child abuse likely to produce great bodily harm or death of Mateo G. in violation of Section 273A, Paren A of the Penal Code as charged in the 4th count of the information. Signed, foreperson.
Thank you. For the jury, is that your verdict that has just been read?
Yes.
Would either side like me to poll?
No, thank you.
Any legal reason why the court should not accept the verdict that has been reached?
No.
The court does accept the verdict, will lodge it, and declaring a mistrial as to count 1, which then necessitates a mistrial as to count 2 being a lesser included offense. So for the jurors, I have one final jury instruction for you, and then we'll have you return briefly back to the jury room, and then after that, you'll be free to go. You have now completed your jury service in this case. On behalf of everyone involved in this trial, thank you for your time and your effort. Now that the case is over, you may choose whether or not you wish to discuss the case and your deliberations with anyone that you want. I remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Let me tell you about some rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant or their representatives, may now talk to you about the case, including your deliberations or verdict. Those discussions must occur at a reasonable time and place and only with your consent. Please tell me immediately if anyone unreasonably contacts you without your consent. Anyone who violates the rules violates a court order and may be fined. I now order that the court's record of your personal juror identifying information, including your names, addresses, and telephone numbers, be sealed until further order of this court. If in the future the court is asked to decide whether that information would be released, notice would then be sent to any juror whose information is involved. You may oppose the release of the information, and you may ask that any hearing on the release be closed to the public. The court would then decide whether and under what conditions any information may be disclosed. I want to thank you again for your service. This is a very difficult subject matter in this case, and each of you were willing to serve as jurors, and we commend you for that. And wish you all happy holidays with your families. Good new year. This time you are officially excused, but we'll have you step back briefly into the jury room, and then we'll excuse you from it. Okay? See you in just a couple minutes. In this case, counsel can have a seat. In this case, we do have a conviction on 2 counts plus the finding. Is there any further, and I'm just asking juror number 1 right now, we'll go down the line all the way. Is there anything further closing argument on a specific issue from the attorneys, any clarification of the law by me, any questions that you have of the court that you think would be of assistance in reaching a unanimous verdict? 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Counsel satisfied? Yes. You have reached a verdict as to counts 3 and 4. Is that accurate? Yes. You hand the verdict form to our bailiff, and we'll take the verdict on those 2 counts. Had multiple days deliberating, so the one thing I just need you to do is even though you didn't fill out anything for count 1 because we know why, We just need a date on that first page. So we'll hand that back. Do you have a pen with you? We'll give you a pen or bailiff has one. You just fill in the date. Today's date is the 18th. Just on the first page. Yes. And you can give the verdict form to the secretary.
Superior Court of California, County of Kern Metropolitan Division. The people of the state of California versus Maya Hernandez, case BF 205702A, verdict. Bakersfield, California, December 18, 2025. Third count. We, the jury, impaneled to try the above entitled case, find the defendant, Maya Hernandez, guilty of child abuse likely to produce great bodily harm or death of Emilio G. in violation of Section 273A, Paren A of the Penal Code as charged in the third count of the information. Signed, foreperson. Finding on Penal Code Section 12022.95, death of a child. We, the jury, impaneled to try the above entitled case, find it to be true that Emilio G. died as a result of the crime charged in count 3. Signed, foreperson. Fourth count. We, the jury, impaneled to try the above entitled case, find the defendant, Maya Hernandez, guilty of child abuse likely to produce great bodily harm or death of Mateo G. in violation of Section 273A, Paren A of the Penal Code as charged in the fourth count of the information. Signed, foreperson.
Thank you. For the jury, is that your verdict that has just been read?
Yes.
Would either side like me to poll?
No, thank you.
Any legal reason why the court should not accept the verdict that has been reached?
No.
Court does accept the verdict, will lodge it. I am declaring a mistrial as to count 1, which then necessitates a mistrial as to count 2 being a lesser included offense. So for the jurors, I have one final jury instruction for you, and then we'll have you return briefly back to the jury room, and then after that, you'll be free to go. You have now completed your jury service in this case. On behalf of everyone involved in this trial, thank you for your time and your effort. Now that the case is over, you may choose whether or not you wish to discuss the case and your deliberations with anyone that you want. I remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Let me tell you about some rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant, or their representatives may now talk to you about the case, including your deliberations or verdict. Those discussions must occur at a reasonable time and place and only with your. Please tell me immediately if anyone unreasonably contacts you without your consent. Anyone who violates the rules violates a court order and may be fined. I now order that the court's record of your personal juror identifying information, including your names, addresses, and telephone numbers, be sealed until further order of this court. If in the future the court is asked to decide whether that information would be released, notice would then be sent to any juror whose information is involved. You may oppose the release of the information, and you may ask that any hearing on the release be closed to the public. The court would then decide whether and under what conditions any information may be disclosed. I want to thank you again for your service. This is a very difficult subject matter in this case, and each of you were willing to serve as jurors, and we commend you for that. And wish you all happy holidays with your families. Good new year. This time you are officially excused, but we'll have you step back briefly into the jury room, and then we'll excuse you from that. Okay? See you in just a couple minutes.
Wow, big news, breaking news from this jury. First of all, 4 counts against Maya Hernandez. The first 2 counts, the jury is deadlocked. That means they can't reach a unanimous decision. Counts 3 and 4 are the child abuse likely to produce great bodily harm or death. And the 2 deadlocked on, the first is second-degree murder, which includes the unlawful killing of a human being with malice, and the involuntary manslaughter is either without malice or commission of a lawful act that was done without due caution and circumspection.
Yeah, bit of a shocker.
Completely.
I thought certainly either the second-degree murder or certainly the involuntary manslaughter, where we're talking about a conscious disregard for human life for that second-degree murder, it seemed to fit those facts. And as far as the child abuse producing great harm or death, in the case of Emilio, where he died, she's facing 25 to life.
Yes.
So she's not out of the woods yet.
No.
And for the second child, Mateo, where it was great bodily harm, anywhere from 2 to 6 years. So I don't know if it's fair enough to call it a big victory, but certainly a victory for the defense.
And I'm based on the facts. We know this. We know that one of the 2 children died in the car that was too hot. We know she left the children in that car. We know she went in for a cosmetic procedure. All of that together, I am surprised they could not reach a verdict on counts 1 and 2.
The only thing I can think of is they gave a lot of deference to the fact that A, she testified.
Yes.
And 2, she did leave the air conditioning on and didn't know that the car would shut off after an hour. Left them with milk, cookies. So again, doesn't make it right, but I'm just trying to figure out why this jury has
And
struggled
you were right.
with those 2.
Factually, what you just said could sway people in a jury. So I think that may be where they're stuck. All right, stand by. We have to squeeze in a break. When we come back, we're going to get you back inside the courtroom for more of this case against Maya Hernandez. Hung jury on 2 charges, guilty of the other 2 charges. We'll be right back.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
put you back inside the courtroom in California in the case against Maya Hernandez. Michael, 4 counts, a hung jury on counts 1 and 2, counts 3 and 4, guilty charges.
Yeah, just again, a little bit of a shocker. You and I both thought that the top charges kind of fit the circumstances, but obviously this jury disagreed.
That's right. Let's go back inside for more from that courtroom.
In this case, we do have a conviction on 2 counts, plus the finding as to count 3 of death. And that would necessitate, obviously, a report from probation. We do not know at this point whether the people intend to retry counts 1 and or 2. Do counsel wish this to be set for a sentencing date or for an intermediate status date, or you want to wait a couple minutes while the two of you talk and let me know?
I think we're both in agreement for a status date, Your Honor.
Correct. Okay. Can we do that in January?
Yes. Sure.
How about January 12th, Monday?
That's fine then.
Fine with the defense. We have another trial with regard to that trial that day, which gives plenty of time to talk about whatever you want.
I may be sent out in another trial, I do not know.
Whatever trial you're sent out in, they'll need to be dark.
I understand.
So we'll set it for status only as to whether counts 1 and 2 will be retried, and we're setting a sentencing date for January 12th, 8:30 here in Department 4. Mr. Hernandez, you have a right to be sentenced within a statutory period of time and go to trial if those counts are retried within a statutory time. At this time, do you agree to waive time to January 12th plus 60 court days for sentencing and or retrial? Counsel Jones?
Counsel Jones.
Is that acceptable with the people?
Yes.
Okay. And you remain in custody at this time with bail as previously set. And that ends our proceedings for today. We'll have the audience next.
Sentencing set for January 12th, 2026.
Actually, not sentencing, status hearing.
Thank you. I apologize.
Because they still have to determine whether they want to come back and try her again.
Thank you. Thank you for that clarification. Very different things. And we know on that child abuse resulting in death, she's facing 25 years to life. Yeah. Pretty serious sentence. Still with us, criminal defense attorney, former prosecutor Jack Rice, and joining us now from Tampa, Florida, former prosecutor and constitutional attorney Chris-Ann Hall. Chris-Ann Hall is a constitutional attorney. What do you think when they've deliberated 9 hours, 30 minutes? We now know that they were deadlocked on the charges of second-degree murder and involuntary manslaughter.
Well, I think it really shows us that what we have is a highly divided jury. I mean, deadlock means they couldn't come to a decision. And that is going to weigh heavy on the prosecution. As a former prosecutor, I can tell you, even at the status hearing that's coming up, are we going to refile these charges? I personally would take that as a clue that her testimony on the stand was very persuasive, and that the jury, even though they found there was child abuse, that they couldn't raise the standard to murder or homicide.
Yeah, I would have to agree, Chris-Ann. And you know, it's interesting because, Jack, I think the issue, and I felt it might be an issue throughout, was this whole idea of intent. Prosecutor went all the way around to make sure that they explained what they meant by intent. It was implied intent, but that word intent is there, and I think perhaps maybe there's some mothers or even anyone, a father, anyone who has children, just maybe struggled with that intent because they just really rejected those out of hand.
I think they did, Michael. And I think especially the fact and that piece of evidence where she talked about the car shutting off and not knowing that the car would shut off. Yes, clearly child abuse, no question about that. And yet the notion that she gives them milk, she gives them treats, she leaves the car on, she leaves the air conditioning on, I think all goes to that. But what I do think is interesting and what I think is coming, and I see this, again, been doing this as long as I have on both sides of the aisle, is I think what you're going to see is pressure from the prosecution on the defense to resolve this case for a certain period of time, and they're going to try to ratchet it up rather than the notion of coming back and having to try counts 1 and 2 again. So they're willing to dismiss those and they can wrap this entire thing up.
Let me throw that back at you, because my question about that, Michael and Jack, I'll ask you, but Michael, I'd love to hear from you as well. Is 25 years justice? Because I would think if I were the defense, I'd say, sure, we'll agree to 25 years and let's dismiss those others. And I assume the prosecution would probably say, we're going to want more than that. What do you think, Jack?
Me first, Jack.
Yeah, go.
That's why you're not a defense attorney.
That's fair.
I'm not agreeing to 25 years in this instance under any circumstances.
That's my boy right there.
But
Exactly.
it's 25 to life.
I understand, but I'm not going there in this particular instance. I would, at this point, tell them, go ahead and try her again.
Oh,
but anyway,
my
Jack, love to
gosh.
get your thoughts on that.
Now
Then we'll
that's-
check in with you, Chris.
Michael, I'm with you. 25 years is a lifetime. It's a lifetime, and the thing is that if we're looking at 25 years, the worst that's going to happen is that. Why would I negotiate that out? I'm not negotiating against myself. If I'm coming in at that 10, 12-year mark. I'm coming in way down below that with an agreement to dismiss counts 1 and 2 and never retry them. The idea of going to 25, absolutely not. I'll roll those dice again because I had the jury the last time. You screwed up that time. I'm going to come at you again, and this time harder.
And I know we have to go to a break, but Michael, I guess I was thinking if it's 25 to life, you can't even agree to less than 25. But you're saying you could agree to less than 25.
You could agree. You could make a deal. It's absolutely, you can make a deal. No
This
question
is why
about
I'm not a
it.
defense
Chris-Ann, quickly
attorney.
ring in. I got a couple of, about 30 seconds or so.
Yeah, I'm on your side. I think that the prosecution's going to try to push for a negotiation that way. But if I'm the defense attorney, and I'm even going to say this at sentencing to the judge if there's no agreement to be made, the jury already came back and said, this is not a homicide. This is not a manslaughter case. Now let's deal with it as it is, child abuse.
Absolutely.
I'll remain the judge and listen to all of your compelling arguments because they've all been better than any of the things I've said.
You can just ratify
Yes, please.
the deal we come up with.
Yes, please.
All right.
Thank you.
Everybody stand by. We're going to take a break here. Coming up, folks, we're going to switch gears. We're going to head back to Kentucky, where former Sheriff Mickey Steins is back in court. We'll have that coming up next, right here on Court TV.
I can't sit like this.
Slide sideways.
I can't. Come on now. Be fair to me.
We're being good to you, brother. You stick your leg up in there.
Come on now, guys. Please don't do this to me. Please don't do this to me. Please.
You want to scoot on over a little bit to the left?
Come on now.
Try to scoot on over a little bit more. That way we don't hit you. Can you go any bit farther? That's what we'll hit you with the door. Put your knee in there, my friend.
Hey, Jason. Hey, Bates. Hey, Bates. Can we loosen this up a little or give the window down? I'm sorry. Can we loosen this up a little? Be fair to me, man.
That was former Sheriff Sean Mickey Stein speaking to officers after he was arrested and put inside the patrol car, saying he couldn't breathe and asking them repeatedly to be fair to him.
Now remember, he's the sheriff, and Stein is in court this hour for a motions hearing. Police say the former sheriff walked into a courthouse in September of last year and fatally shot District Judge Kevin Mullins in his chambers after an argument. Now, last week, Stein conceded in court paperwork that he murdered a judge in his chambers, but says he lacked the ability to form the intent to kill.
We also know that Stein plans to use the insanity defense at trial. Right now, we are waiting for court to start again on the motions hearing. And while we're waiting, let's bring in former prosecutor, constitutional attorney Chris Ann Hall. Chris Ann, this is yet another case. We've seen lots of these that we've been covering at Court TV with video. The video tells the story. And how hard is it, or is it helpful to have the video for something like an insanity defense?
Well, again, it's a cost-benefit analysis here. It helps some and hurts others. I think the video helps the prosecution a lot because most people have a visualization of what a crazy person looks like. And I don't believe in this situation the sheriff looks crazy. I mean, we can think it's crazy for a sheriff in his position to do this to a district judge, but what is really behind this? I think the biggest factor in this case is this is a town. This is a small town. This is the sheriff. This is a judge. Everybody's going to know about this, and everybody's going to be involved.
And everybody's going to have an opinion, too, which is why, obviously, his attorneys want that change of venue. It sounds, Chris Ann, like you're someone who would argue for that. And in this circumstance, I got to say, I think it's a serious consideration to move this from this particular jurisdiction.
100%. I think it's going to be really hard in this particular area to find an impartial juror, much less a group of impartial jurors. And I think we're also automatically going to see, I hope, some special prosecution assigned as well.
And, you know, we know that he had given a deposition for alleged trade for sexual favors inside the Lecter County Courthouse by a bailiff with former inmates. And this is the hearing live. We don't yet have audio, so we'll just keep the picture up and jump in as soon as we do. But knowing that, Chris Ann, you know, it doesn't mean the prosecution can just bring in that evidence. I mean, there has to be a connection. It can't be prejudicial. It has to be relevant. We don't know any of those things yet.
Well, and I think what we're seeing now, remember, this is a procedural hearing. This is not an evidentiary hearing. And what we're already seeing in this case is that the court is locking down how much evidence is released. They're not going to let any pretrial evidence come out. This is going to have to come in. It's going to have to come in at the right time. It's going to have to come in the right way. All the T's are going to have to be crossed and all the I's are going to have to be dotted because this is so high profile. They don't want this to come back at them. And they want to make sure that everything is established by the numbers.
All right, so we continue to wait for things to get started, for audio to come up in that courtroom in Kentucky. We'll take you there as soon as that gets going. What we'll do right now is we'll take a quick break. We'll see where we stand when we come back. Keep it here on Court TV, your front row seat to justice.
Coming soon to Court TV.
A Microsoft executive gunned down.
Now his ex and her new husband are charged with his murder.
You said I'm gonna kill her.
An alleged murder plot involving a family's au pair and the married father she worked for.
A social media sensation, now a suspected killer.
Why do you have something against me?
She wrote a children's book about her husband's death. Now she's accused of killing him.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
Back now to Kentucky, where we're following a status hearing this afternoon in the case against Sean Mickey Stein.
The former sheriff is accused of shooting and killing a Kentucky judge, Kevin Mullins, in his chambers last year.
All right, been waiting on this whole thing to get started. The judge is now on the bench. Let's take you into the courtroom.
I want to make sure it's done correctly and handled appropriately. So once that issue is addressed, we will reset a date for all pending motions. Anything else on behalf of the Commonwealth?
Will we approach your Honor?
Sure.
Judge, just in regards to the Commonwealth's changes venue motion, I'll take that, but I do have affidavits I'd like to supplement for the record.
Yeah.
They've already been provided to counsel, but I just wanted to make sure the part of the record before I lose
All right.
originals.
All right, so that's it. It looked like it was a lot of much ado about nothing. It happens oftentimes in these types of cases where they need a little bit more time to get their information together. So those motions hearings will not happen until a later date. Let's bring back in our guest still with us, former prosecutor and constitutional attorney Chris Ann Hall. And Chris Ann, again, I want to talk about this defense that we're hearing is going to be put forth by the defense. This idea of a diminished, I think it's insanity. It's not diminished capacity.
I agree.
So it's interesting because I would think in this case, looking for lesser included, so let's say something manslaughter, extreme emotional distress might be a way to go, but they're going all the way to insanity. Your thoughts?
Well, I think you have to start the bar high and see where it goes. The sheriff, the former sheriff, is their client. That might be what's dictating this. And I think what we are going to see at this point is a very deliberate and very calculated move forward. I think that's going to be happening on both sides, again, because this is a high-profile local case. Everybody's going to be moving deliberately. Everybody's going to be moving in a calculated way so that we don't have to, or they don't have to, retry the case again.
Now let's talk about the reality of this sheriff in jail. He's currently being held. He was the sheriff. He was the top dog, and it's a smaller community. You often hear that officers are not treated well by other prisoners when they're in jail. What do you think it might be like, or concerns about his treatment, or is he maybe in, I don't know, solitary is right, but separated from other prisoners? What might you think is going on in that regard?
Well, in my experience, I'm pretty confident that he is not in general population. That is something that is not happening. So they will go out of their way, and there may have already been a deal struck between the defense and the prosecution to make sure that, you know, he might be in solitary based on his mental health status, which would also possibly work in the favor of the defense in their presentation of case, but they're definitely made some kind of arrangements that he is not in general population.
Yeah, that very rarely happens under these types of circumstances, although it's a small county jail probably, so not sure how much danger he is in this particular jail, but again, I think you're absolutely right. He'll be separated. Now, we talked a little bit about the defense, again, this idea that they're going for insanity, and we talked about the video that exists, and it speaks clearly, but I think there's an interpretation that can be made about this video. At one point, he looks at his phone, and that's when this whole thing begins. So what does he see when he's on that phone? There's a lot of speculation that it has to do with his daughter, right? And the fact that the daughter might have been wrapped up in something with this judge. There are a lot of accusations flying around the courthouse. Well, the daughter rang in at some point talking about what was going on. I want to take a listen to that, then I got a question for you, Chris Ann. Let's listen.
Hello, everyone. My name is Lila Steins. I am 18 years old, and I am from Letcher County, Kentucky. Most of you may know me, and the others may recognize my last name. On September 19th, a little over a year ago, a lot of people's lives changed forever, including mine. I'm not going to go into detail. I will not be talking about it, but I just have one question. Do you all not have anything better to do than to sit and gossip? You are taking my pain and making it your pleasure. You're taking our stories and turning them into big entertainment pieces, jokes, and for that matter, you're making it your income. Since when did that become okay? So my advice to the people doing that, get a job, do something meaningful with your life, and contribute to society in a positive way. That's all. I come on here today to address a couple things about yesterday's video. When I posted that video, I only had about 950 followers. I did not think it would go anywhere. I thought, you know, people from home's going to see it, maybe a couple others, and that'll be that. So the first thing I want to say is I had good intentions with that video. A lot of you were asking, what stories? What do you mean by gossip? And what I mean by that is the stories that were made up about me and the other party, and that is where the gossip comes in at. I wasn't actually talking about the situation and what actually happened itself. I was more leaning towards the rumors that had been spread about me. I am aware of how serious this is and how much of a big deal it is. I was not talking about news or social media. I was simply talking about the people who sit at home behind a keyboard all day and say terrible things about my name. That's who I was talking about. At the end of the day, I'm just human. I'm just trying to learn how to process and cope with it all. I do want to add one more thing. A lot of you were saying, girl, this happened a year ago. Like, why are you still going on about it? To you, it happened a year ago. For me, when I wake up, it's the first thing I see on my phone. It's the last thing I see when I lay down, and I'm not looking for it. It's just right in my face. I have to deal with it every day when I wake up, so no, it's not gone. It's not died down. It won't for a while.
All right, Chrisanne, that's the daughter of the defendant. Now, if this insanity defense is based in this idea that he saw something that he thought involved his daughter, she seems to deny it in that could be problematic for the defense.
Well, I think what I take away from that is really what is the real life situation for the people who are collaterally caught up in situations like this. The whole last statement about this was a year ago. We talk about this all the time with you on Court TV about how the victims live these things brand new every single day. So my heart really cries out to her on that. And I think also remembering that insanity doesn't mean that he was always insane. We're talking about a moment where something happened and he lost the ability to control his faculties. Something so traumatic, something so stressful. And when I saw the video and I heard him in custody asking over and over again, I have to see my daughter, I have to see my daughter. I'll have to admit to you, honestly, that's the first place that my mind went. This man, something's going on with his daughter and he's desperately concerned about her well-being. I think we're going to have to wait for the trial to really learn what's going on.
And as we're waiting for this and seeing, I just think that there are going to be a lot of motions about information that's relevant or not relevant. And I think it's going to hinge on that for the defense. I think a lot's going to be argued not to be relevant. And I apologize, Chrisanne. We are at the end of the show. We cannot thank you enough for being with us today.
All right, folks, stick around. Coming up, we're going to head to Georgia, where the father of the alleged Appalachia school shooter returned to court today. That's coming up next, right here on Court TV.
impact to help more kids.
Thank you for giving.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. We are turning now to Georgia, where the father of the alleged Appalachia school shooter returned to court today. Colin Gray faces nearly 30 charges, accused of giving his 14-year-old son, Colt Gray, access to a rifle. That rifle was used in the shooting that killed 4 people and injured 9 others. Colt, who faces more than 50 charges, is currently awaiting the results from a mental health evaluation before his trial date can be scheduled. Meanwhile, today marks the final motions hearing ahead of Colin's trial, which is set to begin in February of next year. Before we go into court for today's hearing, Court TV's own Ted Rowlands with a closer look at the case.
The smart board said lockdown, and everybody ran into the corner. And the next thing you know, I just start hearing gunshots like crazy.
September 4th, 2024 started as a routine morning at Appalachia High School in Winder, Georgia, about 45 minutes outside of Atlanta. It would then turn deadly when police say a 14-year-old freshman, Colt Gray, opened fire, killing 4 and injuring 9 others.
There was 10 shots, about a 3-second or 4-second pause, and then 7 more.
According to investigators, Gray carried an AR-15 style rifle onto a school bus that morning, the barrel sticking out of his backpack wrapped in poster board. They say he left his second period class and started shooting, first inside a classroom and then down a hallway. 4 people would lose their lives that day, 14-year-old students, Mason Schermerhorn and Christian Angelou, 53-year-old math teacher, Christina Arimi, and 39-year-old football coach, Richard "Ricky" Aspinwall.
In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you.
Colt Gray has been indicted on 55 felony counts, including 25 counts of aggravated assault. The teen has pled not guilty. His attorneys say they're awaiting a psychologist report before determining next steps in the case. He is not the only one facing charges in this tragedy.
How old are you, Mr. Gray?
54.
Colt's father, Colin Gray, faces charges of second-degree murder and involuntary manslaughter. Prosecutors say Colin admitted to buying the rifle that his son used in the mass shooting and did so knowing that the teen was a danger to himself and others. He's pled not guilty to the charges.
So did your dad kind of explain everything to you?
He said something about shooting up the school.
Did you say something about school shooting?
I just told him, I don't know what. Maybe they misheard somebody else.
Deputies interviewed the Grays about a year before the shooting, based on FBI tips about alleged threats posted on the online platform Discord. In that interview, Colin said his son had been struggling with bullies, a new school, and his parents' divorce. He also said that Colt was very familiar with guns and hunting, saying he knew the seriousness of weapons.
I don't know anything about him saying like that, and I'm gonna be mad as hell if he did. And then all the guns will go away, and they won't be accessible.
Investigators determined at the time there was no probable cause to take further action, citing inconclusive evidence. The morning of the shooting, Colt's mother, Marcy Gray, said she called the school warning of an extreme emergency after receiving a text from her son reading, "I'm sorry." Here's what she told ABC News.
Between my gut feelings, the text messages, and now this email, y'all need to go, run.
If convicted of murder, Colt Gray faces a life sentence. He is not eligible for the death penalty due to his age. His father, Colin, has been granted a change of venue in his case. If he's found guilty of murder, he could face up to 180 years in prison.
All right, we want to get you into court now for the start of today's motions hearing.
All right, we're all present. State of Georgia versus Colin Gray, 24 CR 593. We are here for motions. If I recall, we did not finish a motion from before because there was a witness that wasn't available. Is that right?
Yes, Your Honor, for the Jackson DNA hearing on the statements.
Okay. Can y'all tell me what motions we are hearing today?
My understanding is we are going to hear the Jackson Deno on one of the statements on the day of the shooting. And then we're also going to have a witness testify about the statement from the year before that was made to the Jackson County Sheriff's Office, to Investigator Miller. And then the other part of the motion to suppress from the previous hearing with the search of the phone, that witness was unavailable. And so she is Agent Ward. She did both the interview and then she also got consent. So.
All right. Is that right, Mr. Hobbs?
That is correct, Judge. And on the motion to suppress the search of the phone, we're going to ask that we can prepare a letter brief, though we will make a short argument just so that we know what we're going to be arguing in that letter brief.
Okay. Yeah, not an issue.
Thank you, sir. Otherwise, we agree with what's left.
All right. Go ahead.
The state calls Agent Kelsey Ward. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Have a seat and introduce yourself for the record.
I am Special Agent Kelsey Ward. That's KELSEYWARD, and I work for the Georgia Bureau of Investigation.
Okay. And what is your role at the GBI?
I am a special agent, so I investigate crimes that we are requested to work by local agencies.
And what region are you in?
I'm in the GBI Region 11 field office, which is located in Athens, Georgia.
Does that include Barrow County?
It does.
And were you in that same role in September of 2024?
I was.
Did you become involved into an investigation into Colin Gray related to the Appalachia shooting?
I did.
When did you become involved in that investigation?
That morning, not long after the incident occurred, my field office responded to the school where I actively became involved in the investigation.
Did you interview Colin Gray?
I did.
And when did you interview him?
I interviewed him later that morning at his residence in Bethlehem, Georgia.
What was the purpose of that initial interview?
We went there with the intention of just gathering more information about the shooting itself and background on his son, Colt Gray.
Where did you first come in contact with him when you got to the defendant's residence?
I noticed that he was sitting on the bed of a pickup truck outside of the residence, and he was sitting on the tailgate of that truck.
And did you approach him?
I did.
Tell us about that initial interaction with him.
I approached him. I introduced myself to him. I explained that I was a special agent with the GBI and that I wanted to conduct an interview with him, and would he be willing to speak with me? And he asked me if I could provide him with any information about what had happened at that time, and I told him I didn't have very much information to provide.
Did he agree to speak with you?
He did.
And was that initial interaction where he was sitting on the bed of the truck, was that recorded on body-worn camera?
It was.
Okay. Was it recorded on a body-worn camera that you had?
It was not.
Okay. Does the GBI have body cameras?
No, I'm not issued a body camera with the GBI.
Whose camera was it recorded on?
It was a Barrow County Sheriff's Office deputy named Anthony Townsend.
And have you had an opportunity to review that recording of your interaction with Colin Gray on September 4th?
I have.
Is it a fair and accurate recording of that initial interaction with him?
It is.
Have there been any additions or deletions?
There have not.
Okay. And at this time, Your Honor, I would like to introduce into evidence State's Exhibit 2, which is a small clip of that initial interaction between Agent Ward and the defendant.
Mr. Hobbs?
No objection, sir.
All right, 2's admitted.
Okay, and we're going to publish that for the court.
Do you need the...
We need...
All right, it's on your
TV.
table. You need the TV.
Yes.
things just for viewers to note. Number one, yes, that is the judge wearing a suit, does not have a robe on, but the judge is hearing this motions hearing. Number two, just interesting, she had to lay the foundation to explain that she is a GBI officer special agent, did not have a body cam on, but a Barrow County deputy was with her, and that is who had the body cam, and that's the video they're going to be showing. Stay with us. We'll bring you more of the motions hearing for Colin Gray up next.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
Before we get you back into court, here's a look at a few other cases that we are tracking this afternoon. In Massachusetts, Brian Walsh was sentenced to life in prison without parole after he was found guilty of murdering his wife, Anna, on New Year's Eve back in 2023. In California, a jury found Maya Hernandez guilty of 2 counts of child abuse after leaving her son in a hot car while she got a Brazilian butt lift. The jury was deadlocked on the most serious charges, including second-degree murder. And in New York, suspected United Healthcare CEO killer Luigi Mangione was back in court for the last day of his long-running suppression hearing. The judge will issue his decision next May. But right now, let's turn back to Georgia in the final motions hearing for Colin Gray. He is the father accused of giving his 14-year-old son, Colt Gray, access to a rifle that was used in the Appalachia school shooting that killed 4 people and injured 9 others. Colin has pleaded not guilty to nearly 30 charges, and he is set to stand trial in February 9th of next year. Let's get you back into court for more of that motions hearing.
As far as more details than that, I'm not going to be able to tell you okay? Is this okay for us to interview here? Would you like to sit in my Tahoe so that it's more personal? Why don't we do that?
And so in that clip, y'all get up and leave. Where are y'all going?
I asked him if he would feel more comfortable interviewing in my state-issued vehicle, which was on scene, and he said yeah. So we moved to my Tahoe, which was parked in the driveway.
Okay, and where in the Tahoe was everybody seated?
So I sat in the driver's seat. Special Agent Amelia Maddox sat in the second row behind me, directly behind the passenger seat, and then he sat in the front passenger seat.
And was your door locked to your vehicle?
It was not.
Was he free to leave at any time?
He was.
Did he have a cell phone with him that he could use if needed?
He did. He had it in his hand for most of the interview.
Was he handcuffed?
He was not.
Was he restrained in any way?
No, ma'am.
And was that interview recorded?
It was.
And how was it recorded?
It was recorded on my digital recorder that I use for all of my interviews.
Have you had an opportunity to review that interview, which is State's Exhibit 1?
I have.
Okay. And again, is it a fair and accurate reporting of your interview with the defendant on September 4th?
It is.
Any additions or deletions to it?
No, ma'am.
Your Honor, this time I would like to introduce into evidence State's Exhibit 1 and provide it to the court to review at a later time.
Mr. Hobbs?
No objection, Judge.
All right, State's 1's admitted.
Approximately how long was your interview with the defendant?
It was about an hour and a half long.
And what time did that interview conclude?
At 3 p.m.
How old was the defendant at the time of the interview?
He was 53.
And could he read and write?
He could.
During the course of the interview, did you promise him anything to get him to talk to you?
I did not.
Did you threaten him or coerce him in any way to get him to talk to you?
I did not.
Did you provide him any hope of benefit in getting him to talk to you?
No, ma'am, I did not.
Throughout the interview, did you maintain a conversational tone?
I did.
Did you ever raise your voice?
No, ma'am, I did not.
Did it ever become contentious at all?
No.
In your training and experience as a law enforcement officer, have you had the occasion to come in contact with individuals under the influence of alcohol or drugs?
I have.
Did the defendant appear to be under the influence of any alcohol or drugs?
He did not.
Did he appear lucid and able to understand the questions that you were asking him?
Yes, he did.
Was he able to answer those questions?
He was.
To the best of your knowledge, were the defendant's statements given freely and voluntarily?
They were.
At any point, did he ask to end the interview or leave the car?
He did not.
Did he ever ask for food or water?
No.
Did he ever ask to use the bathroom?
No, he did not.
At the end of the interview, was he free to leave?
He was.
And did you, in fact, leave him at his house at the end of the interview?
I did.
Okay. Now, In addition to doing that interview, did you also seize his cell phone from him? Okay. Before seizing his phone, during the course of the interview with him, did he show you his cell phone?
He did.
What was he showing you on his phone?
A number of different things. So he showed me text messages that he had sent and received from his son, Colt Gray. He also showed me emails that were in reference to obtaining counseling services and communication about counseling for Colt Gray.
And was he actively bringing out his phone, showing those to you, and kind of manipulating his phone?
He was. So we would talk about something, and then he would show me the text messages, and then we'd talk about it, and he'd show me the text messages, and it went back and forth that way.
Did you ask to photograph the phone?
I did.
And did he allow you to do that?
He did. He let me take screenshots.
And how did he do that? Was he holding the phone and you taking pictures?
He was holding the phone, and then I used my state-issued cell phone to take pictures of what was on his screen.
So after the interview was over, did you then ask for consent to seize his phone and to search it?
I did.
Tell us about that.
So when the interview concluded, as we were exiting the vehicle, I made the decision that due to the rapport I had established with him during the interview, that I was going to ask if he would be willing to consent to turning his cell phone over to me. I presented him with a consent to search form, which is a GBI document, and explained what that meant, which was that we would extract the information from his cellular device using a software program and review that information.
Okay. And when you were requesting consent, was your recording device on at that point?
It was not.
And when had you turned it off?
I turned my recording device off at 3 o'clock when the interview ended inside of my vehicle.
Is that your general practice?
It is not. Typically, I probably would have recorded, but this was a last-minute decision after I'd already finished that interview.
When you, and I'm going to show you what's been marked as State Exhibit 4. Do you recognize that?
I do.
What do you recognize that as?
This is the waiver of constitutional rights to a search warrant of an electronic or cellular device.
And is it a fair and accurate copy of the waiver that you provided the defendant?
Yes, it is.
Okay. Your Honor, this time I'd like to introduce into evidence State Exhibit 4, which is the consent form signed by Colin Gray on September 4th.
Mr. Hobbs.
Just to put on the record, what cell phone was that for?
For his cell phone.
Yes. It was his black and color iPhone 14.
Perfect. No objection, Judge.
All right, Stage 4 is admitted.
When, kind of take us through how you showed him the form. Did you read it to him? Did he read it?
Yes, so I discussed with him that he was going to be signing this if he gave his consent, and that it allowed me to seize and then search the electronic device without a warrant, and that he had the right to refuse to consent to that if he did not want to go along with that. And then I put in here the description of his cell phone, which was, I believe we determined it was an iPhone 14 in a black OtterBox. And then he signed it, printed his name, and then I put the time and date on there so that he would know what time this consent form was filled out. And then I also asked him for his password, which he did provide to me and is written on this form.
And that was the password associated with the phone that he provided you at that time?
Yes, the black iPhone.
All right, let's bring in trial attorney and family law attorney Michelle Thomas and take a break so we can digest some of what's happened. Michelle, great lengths the prosecutor has gone through with this special agent with the GBI to make clear that this was at the residence. Colin Gray had been sitting on the back of his truck, that he was not under arrest. He had his cell phone in hand. She was talking conversationally, all to make a point, I suspect, of he wasn't arrested. What does that mean in terms of his rights and what law enforcement can and cannot do in seeking information from him?
Yeah, good afternoon, Judge Ashley, and it's great to be with you. So what the prosecutor's trying to show is that he gave his statements voluntarily, that he literally signed a form, a consent form, stating that the investigator could essentially search and seize his cell phone. She essentially advised him of his rights, that he didn't have to consent. And so what she's saying is that none of this was due to coercion or force, but it was a voluntary act. And so what the issue is whether his Fourth Amendment right regarding search and seizure have been violated or not. This isn't about whether the evidence is compelling. It's about whether it was obtained legally and therefore would be admissible at trial. These are keys to the prosecution's case, and so that is why they're taking their time to methodically walk through the fact and show how the evidence was obtained legally in this case.
And what other, so we know this is a motions hearing. It's all about whether or not this video is going to be allowed to come in at the trial for Colin Gray, which is scheduled at the beginning of 2026 in February. So my question is, what other types of things might be valid legal arguments to say to the judge, this has to be excluded from evidence and cannot be admitted? Or if you're the prosecution, it absolutely should be admitted?
Yeah, well, the defense, they're fighting vigorously, right, to protect protect his rights. So they're arguing that none of his statements were voluntary, that he didn't know or feel as though he could just simply leave the way that the investigators testifying in the prosecution's case. They're going to argue that he gave these statements under coercion or under duress, and that he wasn't legally advised and should have been properly legally advised or had an opportunity to consult with counsel before engaging in these interviews, speaking at length with the investigators. So even though it may have been at his home and he may have been technically free to leave, that there was still a coercion essentially happening in the moment that where he was unable or felt that he couldn't just leave or stop talking. And so they're trying to show that there's bias essentially with the evidence and ensure that he gets a fair trial.
And I'll be looking forward to seeing that video so we can see firsthand what was asked, what was said, how it was said, what he responded, because I suspect he never thought that he would be charged with second-degree murder as well as involuntary manslaughter, multiple counts. All right, if you would stand by, please, ma'am, we are going to need to squeeze in a break here, but when we come back, you don't want to miss it. We're going to have more of the motions hearing for Colin Gray in Barrow County, Georgia, up next. Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you. We are in Georgia for a motions hearing for the father. He is accused, he is the father rather, of accused school shooter Colt Gray. He is accused of 2 counts of second-degree murder. Prosecutors say that he gave his 14-year-old son access to the gun that the son allegedly used in the deadly shooting at Appalachia High School in September of just last year. Let's go back inside the courtroom now and hear more of the motions hearing. They're hearing from a special GBI agent, and it's about body cam video. She went to speak with the father. She had a conversation with the father. The question is whether or not that body cam video from another deputy present can be allowed for the trial. Let's go back into court.
Did he have, in there you mentioned that it told him about his right to revoke consent.
Yes.
Did he have the means to be able to revoke consent?
Yes, so I made sure that since I was taking his electronic device, that he had my phone number so that he could reach out to me at any point to communicate with me that he did not want us searching that phone. And then I do believe he also provided me with his daughter Jenny's phone number at that time so that I had a way to reach him as well, as she would still have her cell phone.
In order to get him to give you his phone and to allow you to search it, did you threaten him?
I did not.
Did you coerce him in any way?
I did not.
Did you offer him any hope of benefit to give you that phone and allow you to search it?
I did not.
Did he voluntarily provide you the phone?
He did.
And did he freely and voluntarily agree for you to search his cell phone?
He did.
At any point during your interview or during your discussion with him about the phone, did he have any questions about consenting to search, or did he express any reservations about giving you the ability to search it?
No, the only thing he asked is that he take some phone numbers off of his phone before I took it, which he did.
At any point, to your knowledge, did he withdraw consent to search his phone?
He did not.
Did he ever call you after you got his phone and ask that, hey, I don't want you to search it?
He did not do that.
And did he ever say that at any point while you were there?
No, ma'am, he did not.
I don't have any further questions at this time.
Okay. All right, Mr. Hobbs, cross.
Yes, sir. Good morning, Special Agent Ward.
Good morning.
My name's Brian Hobbs, and I represent Mr. Gray. If I ask a question that's not artfully stated or is confusing and ambiguous, whatever, just let me know and I'll try and rephrase it.
Yes, sir.
Okay. So you arrived at Mr. Gray's property around 3 o'clock in the afternoon on that day?
No, I arrived at his property around 1:35 p.m.
Okay. Can you describe the scene when you arrived at the property?
Sure. There were multiple law enforcement personnel at the scene. There were deputies, and then I also believe there were some federal agents there with the FBI. And then myself and Special Agent Amelia Maddox with the GBI.
Okay. When you say multiple, if you're able to estimate for me, how many law enforcement officers would have been there?
I'm going to say anywhere from 10 to 20.
Okay. And I assume they were all in uniform?
Uniform, not necessarily. So every agency has a different criteria for what you wear to a scene. And since this was a situation where lives were at risk, you responded in whatever you were wearing at the time. Okay. So some of the agencies wouldn't have necessarily been wearing uniform, but they would have been wearing something that signified they were law enforcement.
Something that would have identified them
Yes.
to a normal person that they were law enforcement.
That's correct.
Okay. And did any of these law enforcement agents that were there, were they carrying firearms to your knowledge?
They were.
Okay. Were you carrying a firearm?
I was.
Was Special Agent Maddox carrying a firearm?
I do believe she was. That is typical of us to carry a firearm.
Gotcha. Now, it appears from the video that we saw, and I know that may not be inclusive of everything that happened with your participation, but it appears that, was it you and Special Agent Maddox that approached Mr. Gray when he was sitting in the back of the pickup truck?
It was.
Okay. And was that the first time you had spoken to Mr. Gray that day?
It was.
You asked him if he'd like to talk to you, presumably.
Yes.
And then asked him if he would like to do that someplace more private, which ended up being your Tahoe, it sounds like.
Yes.
Okay. And you and Special Agent Maddox, I don't know if that would be your official uniform, but it did appear you were dressed in something similar to each other.
Yes, so that is typical of what I would wear on a day-to-day basis, either a blue T-shirt that says GBI agent or a blue polo that says GBI agent, or something that says GBI agent, and then tactical pants.
Gotcha. And when you took Mr. Gray to the Tahoe, is the Tahoe marked as a GBI vehicle?
We drive unmarked vehicles, but there is a light bar that is obvious on it. You can see the lights in my push bumper on the front of my vehicle, but there's no marking that signifies it's a law enforcement vehicle.
Okay. So at that point, you, Special Agent Maddox, and Mr. Gray got into the Tahoe.
Yes, sir.
During your interview with Mr. Gray, was he asking questions about your investigation, trying to gather information about what was going on with his son?
Very limited, actually. He asked me initially when I walked up, which you can hear on the footage, if there's anything I can tell him about what's going on. And I let him know that this is an evolving investigation and there's not much information I can give him at that time. I did let him know that his son was in law enforcement custody.
And that was at the beginning stages of your conversation with him, is that correct?
That was when I walked up to the truck.
Before even you got to the Tahoe?
Yes, sir.
All right. So you've given us the orientation of where everybody was sitting in the Tahoe. And presumably at that point, you still would have had your firearm on, is that correct?
Yes, sir.
As did Special Agent Maddox.
Yes, sir.
And to refresh my memory, I apologize. Mr. Gray was in the back seat or was he in the passenger seat?
He was in the front passenger seat next to me.
Okay. And you stated that at some point he voluntarily offered to show you text messages and emails on his phone. Is that correct?
Yes, we were discussing this and he said, I'll show you. And he showed me text messages and emails that were on his phone.
In the email.
All right, still with us, trial attorney, family law attorney Michelle Thomas. Michelle, something really stood out to me during this cross-examination, and that is that she said to the father, do you want to talk more privately somewhere? And they went and got in the Tahoe. That's the vehicle for GBI special agents that they'd been driving. Is there a potential argument that he then felt like he was in fact restrained or couldn't leave, or that this wasn't free and voluntary?
Absolutely, Judge Ashley. I think the defense is doing a great job of painting that picture of intimidation for this defendant, talking about there were possibly 10 to 20 officers there. Some of them were in uniform, some may not have been in uniform. Imagine how many cars were there. And even though she testified that some of the cars were unmarked, she said there were clear, visible lights, police-type lights in the vehicles. They were wearing firearms, showing up 10 to 20 officers surrounding this defendant with firearms is going to create an intimidating environment that makes one think that they could not just easily walk away, that he had to remain and answer questions and do so, to the defense's point, involuntarily.
You're right, and they're doing a great job because they're so conversational and asking the questions on cross-examinations, very cordial, very comfortable and casual, but getting some good information on the record. Stand by if you would, please. We're going to have more questions for you, but we need to take one of those breaks. After we come back, more of the motions hearing for Colin Gray. Stay here on Court TV, your front row seat to justice.
Soon to Court TV.
A Microsoft executive gunned down.
Now his ex and her new husband are charged with his murder.
I'm gonna kill her.
An alleged murder plot involving a family's au pair and the married father she worked for.
A social media sensation, now a suspected killer.
Why do you have something against me?
She wrote a children's book about her husband's death. Now she's accused of killing him.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.